Good morning, everyone. Welcome to our program this morning. It's a combination of the construction law series with the employment law series, and the topic for today will be hot employment issues. My name is Michelle de Oliveira. I'm a partner at the firm, and my practice focuses on employment law.
And good morning, everybody. My name is Greg Vanden-Eykel. I'm also a partner with the firm, focusing on employment law, and we're excited to provide you with this presentation this morning. And we have about 8 topics that we're going to touch on today and provide an overview of these issues and things to be on the lookout for. The first topic, which is probably garnering the most national press right now, but is not actually implemented to date, is the Federal Trade Commission's proposed rule banning non-compete agreements holistically, comprehensively. The rule was published on January 5th, 2023, and it is open for public comment until March 6, 2023. As you may understand from your day-to-day activities in Massachusetts, we have strict non-competition rules and laws in order for the agreements to be enforceable. But nationwide, the agreements are relatively employer-friendly, other than maybe in California. But the FTC is proposing to ban non-competition agreements for every type of employee as a whole. So this would apply to part-time employees, temporary employees, full-time employees, no matter what the role or essential functions of the position are. Non-competes would be unenforceable under this rule. The only exception is in the sale of a business if a partner, manager, or owner has 25% or more of an interest in the company, that person could be subject to a non-compete. What makes this rule, the proposed rule, also so groundbreaking and game-changing is that it will make non-competition agreements that are in place prior to the implementation of the rule, it will make those agreements unenforceable as well. And employers will have a affirmative duty to notify employees subject to non-competition agreements in writing that their non-competition agreement is no longer enforceable. We expect numerous legal challenges to this agreement, particularly related around to the scope of the FTC's authority to promulgate this rule, but it's something to keep on the horizon and consider as you're moving forward. If non-competition agreements are part of your normal practice, or if you are considering non-competition agreements in the future, this will certainly play a significant role in that decision-making process. We don't expect a final rule or implementation really anytime soon, primarily because of the legal challenges, but something to keep on the horizon, and in the meantime continue following Massachusetts laws and consulting with your attorneys related to the proper language that must be included in non-competition agreements if you want to make those enforceable, which I'm assuming you will want. And so that's kind of a quick overview of that, and we'll continue to monitor this situation and provide guidance as the situation changes.
So Greg and I couldn't talk about hot employment issues without talking about wage and hour. It is and it has been a hot topic, something that employers are obligated to sort of understand and work with, and we really recommend implementing best practices when it comes to wage and hour, because if you're employing folks and you have employees, you're paying them. So it's something that really becomes unavoidable for employers. I will also note that even though we're going to be talking about 8 topics, Greg and I could spend hours on any one of these topics. So the purpose of the program this morning is really to provide a broad brush and talk generally about these topics, and to hopefully get those who are watching and companies to start thinking about what are the best practices that you have implemented in your business with respect to these issues, and are there any other issues or processes that you could embrace or develop to ensure compliance. And at the end of the day, the risk ultimately is to decrease potential exposure to claims relating to any one of these issues. So with that, let's jump into wage and hour. So last year in April of 2022, there was a groundbreaking decision issued in Massachusetts. By this point, I think most businesses and HR personnel are familiar with this decision, and more importantly, what are the implications of the decision? The decision I'm referring to is the Reuter versus City of Methuen. And basically, this decision held that employers who are late issuing payments to their employees are automatically on the hook for treble damages, which means paying the employee 3 times the amount of the late wage payment, in addition to attorney's fees. And after this decision was issued, Greg and I have been hit with numerous demand letters that our clients have received to try to defend these potential claims and also litigation arising therefrom. So again, what does this mean practically speaking if we break this down? The question is, so what? Well, the so what is employers must and are highly encouraged to have processes and procedures in place to ensure prompt and timely payment. For employees who are terminated, they must be paid on the last day of employment or on that effective date of termination. For employees who resign, they must be paid on the pay period following their last day. And it is important, right? It's not a day late, it's not 24 hours late, it's not you're mailing a check on the last day. The bottom line is the employee needs to have those funds available to them on that last day of work in the event of termination. It also means that employees need to be paid timely. So what do we mean by that? Well, employees who are working with you, right? We're talking about folks who haven't been terminated, who haven't resigned, your employees who are working for you. They need to be paid within 6 days of the conclusion of the pay period, which means you must be working closely with your payroll provider, whether you do it in-house or whether it's ADP or Paychex, to ensure that your employees are being paid within 6 days of the conclusion of the pay period. There are only 2 exceptions, and the exceptions apply to casual employees or for those employees who are working less than 5 days in a work week, or for employees who are working 7 days in a work week. Those employees can be paid within 7 days of the conclusion of the pay period, and unless the employee falls within one of the exceptions, then payment must be made within 6 days. Unless, and I think employers have to think about the folks who are getting a check as opposed to getting paid via direct deposit. And then you should ensure that there are processes in place that will allow your employees to have those funds available within these time restrictions to ensure that the payment is received timely. The burden is always on the employer to ensure timely payment and not on the employee. And this is really important because at the end of the day, employer, you're the one with the responsibility to ensure timely payment. With that, we're going to move into a topic that's very much related, and that is vacation. So in Massachusetts, employers do not need to provide vacation to employees, period. There's no law that requires it. That being said, a lot of companies decide to provide paid vacation as a benefit, and that's perfectly fine. Employers need to know that once you do that, what happens is that vacation and the wages being paid to an employee for that vacation becomes a wage that is governed and covered by the Wage Act. With that said, there are things that employers should strongly consider doing as best business practices. For example, having a clear policy that discusses what the vacation provided to employees will be. Will that vacation time be front-loaded? Will it be accrued? What are the parameters governing the vacation policy? And employers have ample flexibility with how to manage a vacation policy. The key and the recommended approach would be have a written out policy, be sure it's clear, be sure your employees are on notice of it, and be really careful when attempting to or thinking about clawing back wages because employees overused vacation. What do I mean by that? If you have a policy that requires that vacation time be accrued, and an employee uses more vacation than what they have accrued, employers may think that they can just go ahead and claw back that time. We don't have time to dig into all of the details, but what I will say here is that there are restrictions around when and how an employer can claw back wages. And the key legal term would be, is it a valid set-off or not? In order for something to be a valid set-off, the question becomes, is there a clear and undisputed debt that the employee owes to the employer? Key terms, clear and undisputed. Is the employer and the employee in agreement with that debt that the employee allegedly owes to the employer for overusing vacation? And this oftentimes happens with loans that employers can provide, wage advancements, or vacation advancements. And is there an agreement? If we take it a step further, the question becomes, is there an agreement between the employer and the employee through which the employer is entitled to claw back that vacation time? And again, the question becomes, are both the employer and the employee clear on the existence of that agreement and on the amount of the debt? There are ways in which an employer can protect itself from having disagreements with an employee about the existence and the amount of a debt. And we encourage employers to really think about that closely when trying to implement these policies or try to claw back wages. There is a way for employers to implement use it or lose it vacation policies. I just want to put a little asterisk on that note, on that point, and note that if businesses are thinking about implementing use it or lose it policies, meaning you either use your vacation and if you don't, you lose it, there are strict requirements that pertain to such policies, and we encourage you to think about it closely and seek the advice of counsel when trying to implement these policies. The last point I want to note is that oftentimes companies will decide to combine a vacation policy with a sick time policy so that the company just has one bucket of PTO, paid time off. It is perfectly fine to do it, but it can be nuanced depending on how the company wants to implement the policy. One of the reasons for that is that sick time is not a wage under the Wage Act, which means sick time does not, by law, have to be paid out upon termination. And employers also need to adhere to requirements that are embedded into the sick time regulations when having policies that combine the two, because at the end of the day, and in short, the vacation policy, when combining sick time, needs to be sure that it is being as generous as what the earned sick time law and regulations require. And employees need to have all of the rights within the sick time law. For example, I'm just going to give one example. Incremental use. Under the sick time law, employees need to be able to use sick time in increments of 1 hour or at the smallest increment that the payroll provider can track. So if you're combining a sick time and vacation policy into one PTO bucket, perfectly fine to do that so long as incremental use of that PTO is permissible under the policy. So again, these are things that companies and employers should be thinking about when combining these policies, and we don't have time to dig into all the details, but these are really important points that everybody should consider. And with that, I'll turn it over to Greg.
Right. So we're going to switch gears a little bit, and I just, to reiterate what Michelle said, we could spend all day on the wage and hour, vacation, sick leave. We just encourage, we just don't have the time, but we do encourage you to consistently review those policies and make sure that you understand your obligations as an employer because of the significant damages that are at issue should those laws be violated. If there's anything that you take away from this presentation, it's the essential nature of understanding wage and hour laws. But with that, we're going to move. The next topic is what we like to call multi-jurisdictional compliance, which is a phrase only lawyers could love, but really means, how is your company operating, particularly in this post-COVID world, where you may have employees in different states. Pre-COVID, most companies probably had employees only where they had physical office locations. It's convenient in New England to have locations in Massachusetts, Rhode Island, New Hampshire, and you'd be familiar with those laws and those requirements. But during COVID and the increasing reliance upon remote workers, and post-COVID, where remote work is now seen as an employee benefit, employees were hired based on talent, and it was easy to find somebody in Texas or Oregon or California that may fit the needs of your company, but your physical location is only in Massachusetts. And what we want to talk about here with this multi-jurisdictional compliance is the legal considerations for operating your business in multiple states. The first, the essential question, the essential point, which may seem straightforward, is employers need to know and understand where their employees are actually working and where they're living. If you're hiring employees and they're going to work remotely or even partially remotely, there has to be an understanding as to where that employee is physically located, because that physical location triggers specific obligations for you as an employer. So if you are a Massachusetts-based employer and you hire somebody from Oregon who's working remotely, you need to be aware of Oregon's state laws related to wage and hour, leave laws, sick time, unemployment, all of the things that you may take for granted because you've focused on those in Massachusetts for years. But those employees who live in Massachusetts or California, they are subject to those state laws, which then subjects you as the employer to those state laws. One thing that has come up actually, which I didn't know until really the COVID era, we mentioned that knowing the state laws, rules on wage and hours and unemployment, but workers' compensation is a big one. I have actually had this come up a couple times, and I learned that Texas, for example, is the only state that does not require workers' compensation. So if you hired employees to work remotely from Texas, you may not need to provide them with workers' comp, and that's a consideration. It's permissible and it's recommended, but it's not required. So those are some of the challenges that we hadn't really considered 3 years ago. The other thing that has come up a lot is when you have an employee working in another state for your Massachusetts company, for example, that employee that you are arguably and most likely transacting business in that state where the employee is working. Every state has different laws on what's defined as transacting business as a corporation. But if you are transacting business in that state, you will need to be aware of those laws, and you will likely need to register your company as a foreign corporation in those states. Failure to do so may subject your company to the inability to take advantage and avail itself of the laws of that state. So if your company is sued, but you're not registered in that state, you lose a lot of defenses. You may not be able to have that suit insured. It may not be insurable. There's a whole series of ramifications if you don't register. So something to consider when you are hiring remote employees is whether or not you need to register to operate in those states. And we highly encourage you to consult with counsel as you are hiring remote employees. Much like any other area of employment law, clear, consistent, updated policies related to multi-jurisdictional operations are essential. Employees need to be on notice of what their obligations are in these situations, and it also will prepare your management and supervisors with respect to answering questions about how your company operates in Oregon or Michigan versus Massachusetts. One thing that I would just recommend in this arena is make it clear to your employees who work in other states that, particularly with the ability to work anywhere now, that when they are traveling, they're not really supposed to do work in that state that they travel to. If they're a remote employee who lives in Oregon, for example, I keep picking on Oregon, but why not? If that employee lives in Oregon and you know that, make it clear to that employee through your handbook that if they go to California on vacation or if they can take a long weekend in Washington, that they need to notify you and they need to get written authorization to actually operate and work while in those other states, because failure to do so could increase liability for you as the employer, which will kind of segue into Michelle's next topic.
Absolutely. Thanks so much, Greg. So this notion of, employees working in various states and employees working remotely ultimately turns on the question of, okay, what do I do to manage remote employees? And how do I implement hybrid work schedules? And what are the risks associated with that? And what are some best practices as a company I can embrace to ensure that my expectations and the policies are communicated clearly to employees? At the end of the day, I think most employers have seen that one of the many things that COVID has done is raise awareness to the benefits associated with remote work. Some companies were open to that, other companies were not open to that. But even if companies were not open to it, we have seen a lot of companies make that shift because employees want it, employees are asking for it. And there's a big issue right now with companies not only trying to attract new talent, but companies trying to retain talent. And remote work and the ability to have hybrid work schedules is a new or newish employee benefit perk that we have seen a lot of companies embrace. So what are some key things? And again, Greg and I could talk about this for an hour to 2 hours. So we just want to focus on, okay, what are some key things that companies should keep in mind? Even if your employees are working remotely, the burden to track time rests with the employer. And this is really important because sometimes I have heard companies say, well, if the employee is working remotely, I have no way to track the time. I don't know what time they start. I don't know what time they end. I'm just going to have them track the time. It is okay to have a system in place whereby the employee will be tracking the time. For example, a timesheet, whether on paper or whether via an app, which is a common time tracking mechanism that we see companies use. At the end of the day, though, once the employee enters the time onto whatever time tracking mechanism the company decides to use, the employer needs to review that or should review it. And if there are ever any questions or inconsistencies, the burden is always on the employer to be sure that the time is being tracked and that it is consistent. What about overtime? If an employer is working remotely and works overtime, does the company have to pay for that overtime when it didn't know about the overtime or it didn't approve the overtime being worked? And the answer to that is yes. So if you have an employee who was working overtime, they need to be paid regardless of whether or not the company approved it. There are ways that you can manage that, though. For example, if you have a policy that says overtime requires a management approval in advance of that overtime being worked, and then you have an employee who is working overtime without getting that advanced approval, the employee can be disciplined. The employee can receive a warning for having violated company policy. But at the end of the day, the employee cannot be punished and not paid for the time worked. And again, this is because that overtime triggers the wage and hour laws that we talked about earlier. So the employee still needs to be paid. Clear expectations are so important. What do I mean by that? I mean a policy that lays out what are the company's expectations with respect to hybrid work schedules and remote work, which at the end of the day could be an employee perk. So what we saw and what I have seen is that sometimes an employee lives in Massachusetts and all of a sudden becomes a remote employee, and then the employee moves to New Hampshire or to Florida, never notifies the company, and then all of a sudden there are a series of meetings that are coming up and the supervisor wants the employee in the office, and the employee says, by the way, HR, I'm now in Florida. Are you going to pay for my flight back? And the employer had no idea, right? So how do you control the workplace, and how do you control what employees can or cannot do when embracing a remote hybrid work schedule? Well, lay it out in a policy. Give your employees notice of what the expectations are. Are they required to be available during business hours, 9 to 5? Are they required to take calls within business hours, or is there any flexibility around that? Because if all of a sudden you're calling your employees who are working remotely at 11 a.m. or at 10 a.m. or at 4 p.m. And employees are not picking up the phone, you have no idea where they are, that could cause some tension or a lack of trust between, the employer and the employee, which again, I think there are ways that a company can try to avoid that by laying out clear expectations. Because then if you're calling an employee who knows via the company policy that the employee needs to be available during business hours and they are not, it's going to be easier to have that conversation with the employee that may give rise to discipline or to a warning. The same thing with company equipment. I want to say have clear expectations with respect to company equipment. If you have an employee working from home, it doesn't mean that the company no longer wants to protect confidential and proprietary information. I think that concern may be elevated when you have employees working from home because you don't know what kind of equipment they're using. Depending on what kind of business you're operating, there may be documentation, contracts, financial information that should be guarded as confidential proprietary information. You want to be sure that your employee is not logging on to, his girlfriend's computer, for example, or his girlfriend's phone and downloading company documents that now somebody else who's not a company employee has access to, and God only knows what they're going to do with that information or how they're going to protect it. So be sure that there are clear guidelines about company equipment, software, and downloading of material. Are you going to be providing a laptop for them to use? Are you going to be providing a printer? What are the parameters and the restraints around that? Because again, if there's ever an issue, the company will be better protected if it laid out clear expectations and requirements via a policy, as opposed to then trying to rectify an issue that the employee really had no idea related to company expectations and requirements. The last point I want to make on this is consistency. We can't emphasize the importance of consistency enough. And by consistency, I mean, if you have a remote work policy, be sure you're applying it consistently across the board. There may very well be reasons why different departments, different positions may be done remotely and some may not be done remotely. And there may be reasons why certain positions can, work more remotely as compared to others. That is perfectly fine as long as there are legitimate business reasons to justify those differences. So let's focus the discussion on similarly situated folks, people who are in the same department, same positions. Once we're dealing with people who are sort of, peers at the same level, it's really important that companies embrace policies and implement them consistently to avoid and prevent potential concerns of discrimination and disparate treatment because somebody is getting more favorable treatment.
So the last topic that we wanted to touch on is broken into two parts, two brief parts, is employee classification / misclassification. I'm going to briefly touch on the exempt versus non-exempt employee, and then Michelle will touch on the independent contractor versus employee classification. This issue is always hot. And the reason for that is that government agencies make this a point of priority to scrutinize and investigate, and the potential damages are significant for violation. With respect to exempt and non-exempt employees, this means whether or not an employee is exempt from overtime and minimum wage laws. The trend is typically to say, an employee is exempt, and we will not pay them, we're not provide them with overtime. But the problem is with that is under the law, the default is that all employees are non-exempt, meaning they are subject to overtime laws, unless an employer can classify that employee's position within one of the statutorily identified exemptions. The most prevalent exemptions are the administrative exemption, the professional exemption, and exemptions for executive employees. And we won't go into the details of each exemption, but the critical takeaway from today is that with each position that you are hiring for, you need to conduct an analysis as to whether or not that position, the functions of that position, fall within an exemption. It's a case-by-case analysis, and a job title alone, or whether or not an employee is a salaried employee versus an hourly employee, those aren't sufficient to properly classify an employee as exempt or non-exempt. This is a critical area for consideration, and as an employer, you need to be reflecting upon this each time you hire an employee or create a new position. And just in the last week or so, a federal court in the First Circuit just reiterated the importance of employer obligations and the burdens that employers have in classifying employees, in entering a decision in favor of employees as to whether or not they were administrative employees and properly classified. So this is an issue that is consistently evolving and requires significant attention on your part.
And it's so important that the analysis be done, even though we understand that it can be time consuming to do an analysis every time you hire an employee. Or maybe if you have never done the analysis, to sit back now and do the analysis for the employees that you're currently employing who are salaried employees. But we can't emphasize the importance of doing that enough, because if there are issues with misclassification, whereby you're classifying somebody who should be hourly as a salaried employee, the risks associated with that are, having to pay the employee overtime for with a 3-year look back for the state wage and hour laws, with respect to overtime that the employee never was paid because they were classified as a salaried employee as opposed to an hourly employee. So again, we understand that it's time consuming, but it's a really important function that this analysis be done to ensure that you're not classifying folks as salaried versus hourly inappropriately. So, and we understand that sometimes it's easier to just classify employees as salary because the company thinks, oh, if everybody is salary, then I don't need to track time. I don't need to worry about overtime. And sometimes companies will do that, not necessarily to cut down costs associated with overtime pay, but to alleviate the administrative burdens associated with tracking time and overtime for hourly employees. But we caution and encourage employers to reassess that and conduct the analysis, as Greg mentioned, because I really think it can go a long way for the company. With that, we're going to jump onto our second to last topic, which is potential misclassification of employees or of folks who should be employees but are classified as independent contractors. We're not going to spend a ton of time on this, and we are already running out of time, and we apologize for going over. But just briefly, in Massachusetts, there is a strict 3-part test that employers have to meet in order to properly classify somebody as an independent contractor as opposed to an employee. And what is the test? I'm just going to read the 3 prongs here. So, employer who wants to treat someone as an independent contractor rather than an employee has to show that the work is done without the direction and control of the employer, is performed outside the usual course of the employer's business, and is done by someone who has their own independent business or trade doing that kind of work. Again, it's a 3-part test. All 3 prongs need to be met. Each of these prongs is very fact-specific and would require an analysis on a case-to-case basis to figure out, okay, what is this person going to be doing? What are the services provided? What kind of industry are we talking about? And what exactly is this relationship going to look like? Again, fact-specific as to each prong, and it's really important that employers, before classifying somebody as an independent contractor, take the time to run this analysis, get the advice of counsel to just be sure you're not misclassifying someone. Because if you do misclassify somebody as an independent contractor when that individual should have been classified as an employee, the risks associated with that are really significant. We're talking about wage and hour violations. We're talking about, benefits that the employee should have been entitled to and never received, and what are the costs associated with that. So again, it's really important to run that analysis to avoid being dinged with, a demand letter or a lawsuit alleging misclassification. And if you're classifying a large chunk of employees as independent contractors, then we're talking about a potential risk of a class action lawsuit, whereby a lot of employees are going to get together and sue the employer for misclassification. There are also civil fines and criminal penalties associated with that. So again, spending the time to figure out proper classification of independent contractor versus employee is really important.
Really quickly, our last topic relates to mass paid family and medical leave. We've done webinars solely focused on PFML, and there is just a plethora of information and regulatory guidance out there related to this law. But the one thing we wanted to touch on, particularly this time of year, is the continuing obligations that you have as an employer to notify employees of their PFML rights. Every year, there are different contribution rates for both the employer and the employee, as set by the Department of Paid Family Medical Leave, and depending upon the size of your company, those contribution rates must be provided to employees annually, and when they change within a certain prescribed period of time, the department has template notices that you can provide to your employees, and we highly recommend that you review your policies to make sure that employees are being notified when the contribution rates change. The other issue that we run into a lot or see is that when employees are to be notified annually of their PFML rights, just generally under the law, and they should acknowledge receipt of these notifications, and those notification acknowledgments should be collected, and we recommend that they be maintained in an employee's personnel record as part of proper record keeping. But also, what I think also falls through the cracks is when new employees are hired at any point during the course of a year, they must be notified of their PFML rights within 30 days of their date of hire. Again, we recommend that be in writing and put in that employee's personnel record. These seem like mundane tasks, but as part of your risk management program, these should just be part of a typical employee orientation onboarding checklist in order to mitigate potential risks down the road due to violations of the PFML statute. No matter if they seem procedural, they subject you to potential litigation and significant damages. So with that, we thank you for your time and your attention and participation. And as we said, we could speak for hours on these hot issues, and there are other issues out there. But if you have any questions, we recommend and encourage you to contact Michelle or me or anybody at Kenny and Sam's. And we look forward to seeing you at our next construction law and employment law presentation. Hope that you have a great day.
Thank you.
Thank you.